This is Ask Todd on the Financial Exchange Radio Network. If you have an existing estate plan or are in the market for one, Todd Lutsky is here to answer your questions and help you plan for later life. Ask Todd is presented by Cushing & Dolan, serving Massachusetts and New England for more than 35 years, helping families with estate and tax planning, Medicaid planning, and probate law. Visit CushingDolan.com. Now, here's Todd Lutsky.
Todd Lutsky from Cushing & Dolan joins us now for Ask Todd. Phone lines are wide open for you to ask Todd your estate planning questions live on air right now. 888-205-2263 is the number. Again, it is 888-205-2263. That's the number to call to ask Todd your estate planning questions live on air. We usually get through 2, maybe 3 on a good day, so get calling early to make sure you get in line and we can get to your question. That phone number again is 888-205-2263. Mr. Lutsky, how you doing today?
I am never better. And you?
I'm okay.
Wow, that's good. So stop.
I did get pulled over yesterday.
I'm pulled over like by a police officer?
Yeah, they came by and said, do you know how fast you were going? And I said, well, I'm just trying to keep up with the traffic. And he looked around. He's like, well, there is no traffic. I go, I know. That's how far behind I am. So,
That's good.
It was fine. Todd, I want to talk to you a little bit about keeping assets in the family after you pass away. I know that obviously with, some basic estate planning, you could say, okay, I want things to go to my children when I pass.
Yeah.
Beyond that, let's say that a child predeceases you or a child gets divorced from their spouse. What other things can you do through estate planning to help ensure that assets remain in your family?
Yeah, I think, well, one quick answer is obviously don't leave them outright. If you leave any assets outright, and I don't want to make it sound like you can't. By the way, folks, everybody's family is different. Everybody's family understands that their dynamics are different. Level-headed kids, not level-headed kids, good with money, not good with money, drug addicts, addiction issues. It could be any number of things, right? But just understand if the trust you prepare says, I divide everything equally to my children and pay it out to them, all bets are off. I think that's where we start with your question, Chuck, is
okay.
that, if you do that, nothing wrong with it, no right or wrong answer here, but all bets are off. Once they're in the hands of the children, they can do whatever they want with it. They can spend it, they can save it, they can, it's included in their estate for estate tax purposes. If they don't spend it, if they get divorced, it is going to be subject to the marriage, so 50% is going to be lost. I mean, it's subject to any other creditors. And it may never find its way to grandchildren if that's one of your wishes. You have to understand that once you put it in their hands, again, all bets are off, but it gives them complete control. Not horrible, but not the way to go.
Talk to me a little bit about the way to go. Like, what is the way to go?
Yeah, so I think at a bare minimum, you should think about, the overall family. If your goal is to say, yeah, I'd like to take care of not only my children, but maybe even take care of my grandchildren, and I might want to do that in a way that doesn't disinherit my children. Like, you don't have to necessarily say, okay, I'm going to give, 20% to my grandchildren and only 80% to my children. What you can do, but somehow that doesn't fit well because you say, geez, I kind of took away from my kids, right? But if you don't want to do that, you can just set up shares equally for the children and the grandchildren at the same time. And if you have that set up, then you can have language in there that allows distributions to come out in the trustee's sole discretion for not only the child, but the child's children. So the grandchildren don't even have to wait until the parent, in this case the child, dies for it to get down to the grandchildren. So if they needed it for college or prep school or some kind of education issue, or, you're taking a family vacation, you can make distributions out in the trustee's discretion to them. That does multiple things. It provides equally to the family without disinheriting kids at all. It allows grandchildren to participate sooner rather than later. And most importantly, it provides that if you haven't taken it, you don't own it. So it's not taxable when you die for estate tax purposes, children, not the parents, children. And if you get divorced, you don't own it. So if you don't own it, it's not a marital asset. So it's actually protected from creditor. So lots of things to think about, not just divorces, but even tax planning is a good idea with sort of hanging on to stuff in a trust for kids.
Talking with Todd Lutsky from the law firm of Cushing and Dolan. Reminder, we still have room on the phone lines for your estate planning questions to Todd live on air. 888-205-2263 is the number. Again, that is 888-205-2263. We're going to take a quick break here, but when we come back, it's going to be right to your questions with Todd. That number, again, is 888-205-2263.
Ask Todd with Todd Lutsky every Wednesday at 10:30, only here on the Financial Exchange Radio Network. Don't miss Ask Todd with Todd Lutsky every Wednesday at 10:30, only here on the Financial Exchange Radio Network.
Still room on the phone lines for your questions for Todd Lutsky. 888-205-2263 is the number. Again, still room on the phone lines for your estate planning questions for Todd at 888-205-2263. Let's go to Phil on the Cape. Phil, what is your question for Todd?
Good morning, Todd. On an irrevocable trust, if you have one of your children as the trustee, do they automatically become the executor?
So the quick answer is no, but let me explain the difference, and maybe this will adjust your question. When people use the word trustee, so things have legal terms of art that mean things to us lawyers, right? So when I hear the word trustee, that means that person is in charge of the trust and what's in it. When I hear the word executor, which, by the way, nowadays the new word that used to be executor is now personal representative, just to be clear. A personal representative is the person who governs the will and the assets that go through probate. So they are completely mutually exclusive. And no, just because you appoint one person trustee does not mean you need to appoint that same person as personal representative on the will. Did that clear it up for you?
Yes, that does clear it up. And just one real quick last question.
Yeah.
Where would you find it when you build the trust? I mean, is it now not the executor? Is that something that I should go back to your office and have it rewritten, looked at?
I'm not sure I'm understanding the question now. So are you asking me, what are you asking me? Who is the trustee on your trust?
Well, no, I know who that is.
Okay.
I'm not sure about the executor or the person of
personal representative.
Personal, yeah.
So what you need to do for your I don't think you need to come in for that. If you've already signed all the documents, at least when we're done, we always send out this book with all the documents in it. There's a table of contents in the book along with a thumb drive. But if you have the book, just open it up and look on the table of contents. You'll see a list. The first two or first one is generally the irrevocable trust, and then the next one is the will. So just flip to that tab, look at the will, and when you look at the very first page of the will, and this is good for everybody if you're not sure who's serving on your will or who's serving as trustee on your trust, this is important. So look at the will on the very first page of the will. Actually, you won't see it on the first page. You're going to have to flip through the will probably to around paragraph 4. But there'll be a heading that says personal representative, or upon the death, upon my death I appoint, and it'll have personal representative and a name there. So in your case, anyway, Phil, it's in bold capital letters, so you can't miss it. So flip through to like paragraph 4 of the will, and you'll see who's listed as personal representative. Now, if you are not happy with who you appointed as personal representative, then yes, you need to make a phone call to us and we can help you change that personal representative. It's perfectly changeable anytime you want. So good news on that front, folks. And I hope that helps a little bit on really what our these are good questions because they're regular operational day-to-day questions for people. And the same thing, Phil, I'll just expand on it a little bit. The irrevocable trust, when you see that, that's on page 1. Right at the very top, it lists who the trustee is. But like I said, if you're not happy with who the trustee is, even though it's an irrevocable trust, you, Phil, have retained the power to change, remove, and replace that trustee anytime you want. So you can change either the trustee or the personal representative on the will if you're not comfortable. So hopefully that's helpful a little bit. And folks, let me get to this. This is great. I'm glad Phil did the planning, but what we didn't talk about with Phil's situation is that this trust likely directs where his assets go when he dies. And that's really what this guide is all about this month, right? How to leave assets to beneficiaries. Well, I'm happy on the one front that he's avoiding probate, and since it's irrevocable, he's protecting assets from the nursing home. All of that is great stuff. But the family behind the estate plan. So then you read this document and it could have all kinds of language in it as to how you get those assets to your family when you die. So many things to think about. What if you're getting a second, what if it's a second marriage for you? What if you have a special needs child? What if you're concerned about divorces of your children? Generation skipping tax planning. There's so many ways to leave the assets to the children. And you got to learn how to do that. So get this guide. It'll teach you how to leave your assets to your family. 866-848-5699 or legalexchangeshow.com. Again, 866-848-5699 or legalexchangeshow.com and learn how to leave your assets to your family. And also for more information, go to our Instagram page at Cushing Dolan PC.
Todd, last segment we were talking about kind of the additional work that someone can do in order to keep assets within a family after passing away. Have you seen instances where the level of control someone tries to exercise goes too far and it becomes just more of a mess for their heirs to deal with because they tried to do too much?
I think I know where you're going with this, and it's very true. So, like, I had somebody who came in just recently, and they were like, well, I'd like it to go to my significant other, but my significant other is a very good person, but not good with money, and so can I have that person be like trustee, but I don't want that person to have to ask permission for every little thing that needs to be done. That's, what I'm saying?
Sure.
And, or they come in sometimes and they say, okay, well, I want it to go out, but I want it to go out for these reasons, A, B, C, D, E, F. Okay, that's it. Well, again, if you start listing things, so there's two issues. One, when you list things, if they're not there, then arguably it can't come out. So now it's too restrictive. So that might be one issue that you're trying to get at, Chuck, is that, I wanted to provide for my family, but by listing items, trying to think of every little thing you need, you could actually be restricting an asset that might help a family member. So rather than do it that way, like we were talking earlier, Chuck, make it this sole discretionary distribution. Don't put items in. This way, no matter what comes up, the trustee and the trustee's discretion can say, yeah, that's a good idea. I want it to go out for this, not have to worry about it being too restrictive. And then you might say, well, Todd, what if that person is somebody who just likes to say no a lot? Well, now isn't it too restrictive anyway? Could be, but what you could do is you could give your children as beneficiaries of that trust the power to remove and replace that disinterested trustee. So the trustee can be a child who manages, invests, does everything. 99% of the job is done by the child or children, but they can't take it. The one thing the disinterested trustee does is exercises that sole discretion. Sounds good, sounds restrictive though. But Todd, if this person said no all the time, couldn't the beneficiary just remove that person and put somebody else on that's maybe more amenable? Yeah, exactly. So that's what we want. But when you give your kid that level of power, that great power, the great responsibility that comes with that power is understand this. If you explain this to children after the parents die, and one kid says, yeah, I get it, I love it, best way to receive an inheritance ever, but the other kid says, I hate it, I want my money today. Well, if you've given the kid the right to remove and replace that trustee, I guess I explained to him, yeah, don't take it, it's not a good idea, but if I say no, you're gonna remove me.
They could put Ronald McDonald as the trustee and say, give me all the money, and I
just give it to him then. So, yes, you give them the power to take it. But, again, how much power you give them is strictly up to you.
Todd, thank you so much for joining us today.
Always a pleasure. Thank you.
This has been Ask Todd on the Financial Exchange Radio Network. Ask Todd with Todd Lutsky has been presented by Cushing & Dolan, serving Massachusetts and New England for more than 30 years, helping families with estate and tax planning, Medicaid planning, and probate law. Call 800-393-4001 or visit CushingDolan.com. The views expressed in this segment are solely those of Cushing & Dolan. Armstrong Advisory does not provide any legal or tax advice. Please consult with your legal or tax advisor on such matters. Cushing & Armstrong do not endorse each other and are not affiliated.